When a loved one faces declining health or passes away, families often find themselves navigating a sea of deep emotional and legal complexities. During these times, having the right legal framework is vital. Please note, this video is for informational purposes only and not legal advice. Today, we will clarify two critical yet often confused roles in estate planning: the power of attorney and the executor. Let us start with the power of attorney, a foundational legal document designed exclusively for when you are still alive. Think of it as a bridge of trust. The person creating the document is known as the principal, and the person they empower to act on their behalf is called the agent. Why might you need one? A power of attorney steps in during crucial moments. This could be if you become medically incapacitated and cannot make decisions for yourself, if you are traveling abroad and need someone to handle affairs back home, or simply if you want a trusted family member to help manage your finances as you age. There are several types of power of attorney. A general power of attorney grants broad authority over your affairs. A limited power of attorney restricts the agent to specific tasks, like selling a property. A durable power of attorney remains in effect even if you become incapacitated, and a springing power of attorney only takes effect after a specific event occurs, like a medical emergency. An agent's authority can be extensive. They might pay your daily bills, manage real estate, handle legal claims, or make healthcare choices. However, every agent is legally bound by fiduciary duty. They are strictly obligated to act transparently and always in the principal's best interest. Let us look at Sarah and her aging father, John. As John's health declines, he struggles to manage his daily affairs. But because John previously established a durable power of attorney, Sarah can step in immediately. Sarah's role springs into action. She uses this legal authority to pay his medical bills, legally sell his home to fund his assisted living, and ensure his doctors provide the exact care he needs. However, there is a strict limit to this power. A power of attorney is only valid while the principal is alive. The exact second John passes away, the power of attorney terminates instantly, and Sarah loses all legal authority. While a power of attorney handles your affairs during your lifetime, the executor steps in when your life's journey comes to a close. An executor is the person officially named in a formal will to manage a deceased person's estate. It is a profound legal responsibility, ensuring your final wishes are strictly and precisely honored, exactly as you intended. The executor's mandate begins with the probate court. Their first major task is filing the necessary legal documents to officially open the estate. Once granted legal authority by a judge, the executor must locate, evaluate, and protect all assets. This meticulous inventory spans everything from house deeds and bank statements to physical possessions like family jewelry. Before any assets can be passed to loved ones, the estate's financial obligations must be completely cleared. The executor notifies creditors, evaluates claims, and writes checks to settle all legitimate debt and tax payments. They must also file the final income tax returns for the deceased, paying any taxes owed directly from the estate's funds. Only once the court is satisfied, debts are cleared, and taxes are paid, the executor reaches their final and most rewarding duty. They distribute the remaining money and physical assets to the diverse beneficiaries, exactly as outlined in the will. Through careful management, the executor ensures your legacy is safely transferred to the next generation. When the creator of the will passes away, the executor begins a legal process known as probate. This court-supervised journey starts with filing the will, followed by the official appointment of the executor. From there, the executor notifies creditors, inventories all assets, pays outstanding debts and taxes, distributes the remaining inheritance, and finally closes the estate. Take David and his daughter Emily, for example. After David passes, Emily steps into her executor role. She organizes his documents and eventually distributes her assets to her brother. But this does not happen overnight. Probate requires patience, often taking several months or even over a year to fully complete as you navigate court requirements. Now that we understand both roles individually, let's put them side by side. The most critical distinction comes down to timing. Think of a power of attorney as your representative while you are still alive, but incapacitated. Their authority springs from a document you sign. An executor, on the other hand, only steps in after you have passed away, and their authority is officially granted by a probate judge. Scope and termination are also fundamentally different. A power of attorney can be as broad or limited as you choose, but their power instantly ends the moment you die. That exact moment acts as a baton pass. The power of attorney steps down, and the executor steps up, guided strictly by your will and state law until the estate is fully closed. But what happens when the same person doesn't hold both roles? Potential conflicts can easily arise. If a financial power of attorney makes decisions that deplete the estate before death, the executor might be left with complicated legal or family disputes to untangle. This balancing act is why clear communication and carefully choosing your fiduciaries is absolutely essential. Estate planning isn't just about managing assets after you are gone. It is about securing your future and protecting the ones you love most. It is the foundation for your family's lasting legacy. A truly comprehensive estate plan requires several vital components working in harmony. You need a solid will to dictate your final wishes, a power of attorney to handle your affairs if you cannot, a healthcare proxy for medical decisions, and often a living trust to seamlessly transfer your assets. Navigating these critical roles and documents can be complex, and a single mistake can derail your intentions. Always consult with a qualified estate planning attorney to tailor a plan that fits your unique life situation. Can the same person be both? Yes, it's common, but their duties happen at different times. What if there's no will? The court appoints someone, and state laws dictate your asset distribution. Can you challenge their actions? Yes, if they fail to act in your best interest, you can take legal action. Will versus trust. Wills require probate after death. Trusts work immediately and bypass probate. How long is probate? It can take anywhere from a few months to several years. Need more info? Consult an attorney or visit sites like probateus.com. Understanding the difference between a power of attorney and an executor is key to securing your family's future and achieving true peace of mind. Thanks for watching. Please like this video, subscribe for more tips, and leave your questions in the comments below. Visit probateus.com to learn more.